Looks like everybody's ready. We will begin with Thomas Story.
May it please the court, counsel. Thank you for accepting further review on this issue. Very much importance to Iowa farmers, lenders, feed suppliers, and I don't want to leave out the cows. Now, to encourage a fluid feed market and to encourage feed sales to livestock producers already burdened with bank debt. That's the purpose of Iowa Code Chapter 570A, a legislative enactment, of course, in response to the farm debt crisis of the 1980s, as recognized by this court in Oyens. Any decision of an Iowa court that would discourage a fluid feed market, that would discourage feed sales to indebted farmers, is flatly contrary to the legislature's intent as acknowledged in Oyens. And
Story, and I would note you're the second former clerk of the Chief Justice to appear in front of us today, so yes.
Honored to be on this side of it now, and I really appreciate it.
Chief Justice, we have a different way. Here's where I'm going to tell you where I'm coming from. I'm not of the viewpoint. I agree with Judge Allers on the Court of Appeals that summary judgment is summary judgment. So we can talk about, legislative intent and wanting to, you still have to prove up your lien. So I'm interested in what the state of the record is on that. You would agree you had to put in some competent proof, something that there was at least $300,000, which is the amount of your lien, the cows had been sold that were worth at least $300,000 in that last, say, dispersal sale that occurred in March and April of 2019, and that the acquisition price of those cows was zero, right? Isn't that essentially what you'd have to show?
I will quibble with that for a little bit. To me, I think that the Court of Appeals opinion and the question just asked is a tacit assumption that the question of did QPF feed the cows that were ultimately sold, did they actually consume the feed, is required. And I assert to you that the legislature did not intend to require that sort of tracing, that sort of proof. And that's why I think this is a statutory interpretation case. Now, I can talk about the facts in the record. I can talk about the tons of, go ahead.
I agree with Judge Allers on what the law is. Is he still wrong about the facts? Is there a fact issue? What's the proof, for example, that the acquisition price of these cows was zero?
And with respect to Judge Allers, yes, he is incorrect in this case. With respect to, I'll do acquisition price first, right? This is logical. This is a dairy. They're in the business of making baby cows so that they can continue to produce milk. In addition to that, we have an affidavit from a nutritionist stating that I've worked with the Etcher Farms. They raise their cows from birth. In addition to that, we have the evidence that QPF supplied literal tons of what's called calf starter feed. Clearly, there are calves on the farm that are eating that. Then, of course, there's the herd schedules presented by Compeer in resistance to our motion for summary judgment. Now, if you look at those herd schedules, you will see there they report that 100% of the cows there are self-raised, and they use that language. The only exception to that is 117 cows that were purchased by EFF from maybe EFI, but the 117 cows is the only competent specific evidence that is presented in rebuttal of what I believe is an undisputed and should be an undisputed fact. Now, the thing about summary judgment, as long as we're talking about it, is that to resist it, there has to be a material dispute. a genuine and material dispute. And as you are all aware of that standard, a material dispute is one that affects the outcome. If you subtract those 115 cows, subtract 500 cows, there's still enough proceeds.
That you have the burden of proof of establishing the lien, right? I mean, so you have to put in competent evidence from which we can conclude there's a lien of at least $300,000 that followed into these proceeds that are now available and are in dispute. Then I agree. Then it's up to them to take their best shot at it. But first, we need evidence of a difference between acquisition price and sale price, and we need evidence that, in terms of overall dollars, there's enough in there to cover the $300,000 from the sales of cows that actually consume the feed. And I see that some of that Johnson affidavit gets you part of the way there, but I don't see it gets you all of the way there.
Well, first, I do believe that we've established that, and it goes to them to produce a material dispute. But here's where, here's what I want to discuss, is what does this statute actually require, and why does it require it? Because what we're talking about here, what these questions and answers are doing, is assuming that the four-word phrase, livestock consuming the feed, has imposed this, what I contend is an unworkable, impractical, cumbersome tracing requirement. The legislature didn't say each livestock. It didn't say specific livestock. It said livestock, and then it made an exception for a portion of livestock. This implies attachment by percentage, by herd. As amicus knows, the legislature didn't even say the livestock. It just said livestock, which again implies that it's by the herd. This is the same herd. Now, why include the section at all then, right? Why do we have this? Two reasons. The lien applies to livestock. They said this because the lien doesn't apply to the farmer's other collateral. The farmer's got tractors and some other things. Why say the livestock consuming the feed? Why say consuming the feed? Because if QPF supplies cow food, then they don't get a lien in the farmer's chickens. Now, this is a sensible interpretation. It gives effect to the clause, and I don't believe that Compeer strained reading does that. And I also want to pick on the tense of this as well. Consuming, not consumed. It's present, it's not past. It does not imply proof that the livestock actually consumed the feed. It presumes, just like the legislature, as this court has found, presumes that new value added to the livestock is attributable to the feed, that the livestock are consuming the feed.
You keep saying that the burden would be impossible. I mean, it seems to me you could take a deposition of some former employee of Etcher Farms and say, hey, when you bought feed, was it generally fed to the livestock that were on the farm then? Yes. Did you buy outside calves? No. I mean, do you raise your calves from scratch? Yes. They could say that. Are in general, were the cows that were around in 2019 cows that were also around in 2017 and 2018 when you bought the feed? Yes. And then you've met your burden, but you didn't do any of those things.
Agree that that would meet the burden that Compeer has alleged should apply in this case. General. Did this happen generally? Are these the same cows? Would you typically have fed them the same feed for dietary consistency? That's not what Compeer is saying we need to prove. Compeer
Accept their position, nor do I have to accept yours. Sometimes we land in the middle, but I'm proposing a middle path maybe. What's wrong with that burden?
The middle path is the one that the district court adopted, a reasonable link. A reasonable link. That's the middle path. That's fair to both sides.
Your argument about the tenses. So the feed dealer provides the feed and assume the producer runs into financial trouble and only an eighth of the feed is actually consumed prior to the time the livestock is sold. The amount of the lien is still valid for all of the feed that's sold, even though the livestock didn't consume it at all, right? I mean,
Thank you, Justice. If I sell one bean of feed and a cow eats it, I get my lien for the full amount of that bean. If I sell a lot of beans and the cow only eats some of them, I still get the lien. And the reason for that is because look at what the legislature tied everything else in this statute to. When they talk about perfection, they tie it to the sale. The 31 days prior to the filing of the financing statement is what that lien is effective. It's perfected for. When they talk about the date of the lien, right? It's triggered by the sale. It's not triggered by the consumption. Otherwise, the legislature, if they wanted to require this,
there's kind of constitutional overtones here. I mean, the bank, or the credit agency, whatever. I mean, they have a property interest. They have a lien. They put money into this farm, and for your client to come in and say, well, their property interest is going to be diminished without our showing that we truly have a property interest in these cows, that's troubling.
legislature has done is recognize that there's a serious problem right now, particularly right now. It's coming back again. If we are going to provide and encourage feed suppliers to provide feed on credit, then we need to make some sacrifices. What I think the language in the case law interpreting this typically describes is as it was a compromise between various stakeholders. Now, this court has imposed record keeping on feed dealers in the past, serial financing statements every 31 days. If you're still providing feed on credit, you need to file again. But nowhere, and other states have these statutes too. There's Montana, Idaho, North Dakota, Minnesota, Nebraska, probably a few others. Other states have these. I have not been able to find one statute that would require a each cow by each cow type proof. I have not been able to find one case that would require that. They just aren't there. And as this court has noted before in Oyens, those states are more cumbersome in their requirements on feed suppliers than ours. This is a policy judgment that the legislature made. Now, if someone wants to tell me that that's unconstitutional, then I think that that's a different argument that we need to address at a different date. But I assert to you that it's not. It's exactly what the legislature intended. Now, I have a few minutes remaining here, and I know you asked about the burden, right? Why isn't it just a deposition? Why isn't it just a request for admission? We're talking about struggling farmers here. They don't know which cow ate what. They aren't keeping careful records. And even if they were, that's not going to include things like which cows ate how much feed and when did they eat it. The way this works practically, and Amicus talks about this, as do we, is that the farmers get the feed. We drop it off. We have the invoices that say that. It goes here, it's delivered there, and they dump it in the trough and they feed it to their cows. The supplier would never have insight into that process unless what Compeer appears to be alleging that we're required to do, if the feed dealer stayed on site for those months that the cow is eating the feed, document, okay, this one's name tag, there's Bessie again, okay, follow her to the trough so that,
And I just think you need evidence, again, the middle position, evidence from which a fact finder could infer that the feed was fed to the cows that are, as to which you're claiming the lien, in general, not cow by cow.
Fair enough. What about the amount of feed provided? There's tons. What about the types of feed provided? What about the deliveries of the feed to there? Counsel is going to speculate, frankly, that while perhaps the etchers could have sold the feed, raised their own grain, and pocketed the difference. There's no evidence of that, but as a feed supplier, aren't we entitled to assume that the other parties to this transaction are acting in good faith?
mean, this is a normal that would be a normal factual inference, and then it would be then shift to be their burden to show that something was done with the feed other than feeding it to the animals. I agree with that.
Honor, we've established that. That's in the record that we've put forward, that we have delivered the feed. Here it is. It's on the Compeer to then come up with specific facts that say, no, they didn't. They did something else with it. If you look at their resistances summary, I see I'm out of time. I'll finish the question if you don't mind, Your Honor. Okay, thank you. If we look at the resistances summary judgment that they submitted, you'll see the phrases could have, might have. It might be conceivable that this happened. I think possible shows up a few times. These aren't facts. The facts that are in the record, I assert to you, and I believe are sufficient to give us summary judgment, which is exactly what the district court did, and which is why the Court of Appeals should be vacated and the district court judgment reaffirmed. I thank you for your time.
Thank you, Your Honor, and may it please Mr. Story and the court. My name is Dustan Cross. I'm an attorney with the Gisselson and Hunter Law Firm in New Ulm, representing Compeer Financial. To touch on some of Counsel's previous remarks, I would direct the court's attention to the statement of undisputed material facts that was submitted in support of the summary judgment motion. It's found in the record, I believe, at the appendix at 290 to 297. That's the entirety of their factual basis upon which they believe they were entitled to summary judgment. That statement, you will see, is noticeably thin on any discussion at all about what happened to the feed or to the cows or the operation from delivery of the feed, assuming that that's established, or we can assume that it happened, all the way through to the liquidation of the herd back in March and April of 2019. Remember, there's a gap.
Isn't part of that, though, that 570A sort of paints with a pretty broad brush and doesn't seem to require the level of specificity I get that you're arguing for, but
Your Honor, on that, you know, I was kind of mulling in my head when Mr. Story would bring out the words fluid feed market, and he got me to it. He did it in the first 3 words, I think. And I would too if I were in his position. But the reality is, as I think Judge Collins noted in Big Sky, you can't just say that and ignore the statutes. You can't just say that and say, well, the legislature apparently was attempting to emphasize the fluid feed market and help the feed supplier, and therefore we'll ignore the rest of the statute. In fact, as has been recognized, Oyens 1, which I believe Justice Waterman's drafted, is very particular about it. Talked about not so much the legislative history, because there really isn't any legislative history, of course, but the Salisbury and Jewell, Drake Law Review article, et cetera. The point was, though, at the end of the day, the court in Oyens went back to the statute and read and applied the statute, and as a matter of statutory construction, determined that the certification procedures in subsection 2 of 570A did not apply in the case of the feed supply because of the structure of 578.5. Fair enough, common ground. The point is that so you've got 570A, you've got point 3, which talks about attachment, the existence, creation of the lead attachment. Point 4, which talks about perfection, the 31-day look back. Point 5, which talks about priority in the feed supply situation. If the other set factors are met, creates a super priority in the feed supplier. Does not have any statutory provisions regarding proceeds or, most importantly, identifiable proceeds. And that's what this case is really about at the end of the day. It's identifiable.
Is your position as wanting to track animal by animal? If you don't think that's correct, tell us what the level of specificity is.
Fact specific, of course, like all these cases in identifiable proceeds. The 9315, 554 9315 on proceeds specifically talks about identifiable proceeds, does allow for other law, mostly trust law, to guide district courts in making those decisions.
Why isn't the herd a sufficient level of specificity?
And remember, in this particular case, we have 3 different entities. This is not one entity. These are 3 different distinct entities.
Okay, so we have the affidavit from Jared Johnson, which is in the record, and he says essentially the feed would have been fed to all the EFF cows that all the dairy cows that ended up being sold, and there are 600 of the 1,200 dairy cows that were sold at the dispersal sale. We have that affidavit, plus there is evidence in the record that would allow one to infer that this dairy farm doesn't buy its calves, or doesn't buy it raises them. And given, well, let me finish my question. Don't shake your head yet. But given those two things, isn't that enough to establish that at least as to the 200 grand that they're owed by EFF, they have a valid lien there?
If you actually count their lien amount, 348, if they want to throw in the extra 26,000. But besides that,
EFF part, which is doesn't that meet their burden for EFF?
look at the actual evidence record. I mean, Mr. Story can tell you, and we can maybe use our what we think to be our common sense as to what we think might have happened, but none of that's in the record. There's no information in the record that it was even delivered. Where is that? It's not from Jared Johnson. He was there. He was not even there until February of 2018.
Not a fact one. Do you agree that there's a super priority lien for the feed?
Feed that was consumed by the livestock.
As a legal matter, I don't care what the facts are or the record is, to what does the lien attach?
Livestock consuming the feed.
Be proof that the animals at issue ate the feed, and that can't be done on a herd basis.
Consuming the feed means, if it doesn't mean animals consuming the feed.
Johnson's affidavit enough. He says 677 of the cows, there were 1,200 sold, 677 of them had consumed the feed. So doesn't that, so there's more that, let me finish.
Chief Judge right now. You need to wait until the justice is done.
Right.
So 677 of the half the cows that were sold in 2019 at the dispersal sale for EFF had the feed in them. So, and the sale price overall was way more than twice the amount of the lien they're claiming. So why isn't that enough? It seems to me case closed as to EFF at least. We can talk about EFI separately, but EFF.
$13,000 check that was issued to Elmwood. They didn't supply any feed to Elmwood, period. I mean, the district court couldn't be bothered with those facts.
But what's wrong with that record? I mean, you've got 677 cows. They consumed the feed. They put it in an affidavit.
Because Mr. Johnson wasn't there, he has no basis upon which his Exhibit A isn't even in the record. He was not there until February, about less, and we're not even sure when he was there, frankly. If you read his affidavit, Your Honor, it'll become abundantly clear. He's kind of vague about whether or not it was him individually or his company, Nelson Consulting, who was actually there, when they were there. And at the end of the day, his primary testimony was based on his review and summary of records in his Exhibit A that he didn't even conclude.
It said, I received the feed and I fed all of the feed to this herd. Is that sufficient?
I'm not even really, Your Honor, just to be clear, I'm not necessarily challenged. I'm just trying to use it, right, and I'm trying to emphasize, do we think that the feed did not get fed? No, it probably did. But my point is that there's such a thin record here. There's no record. They didn't even bother with that step, even that minimal.
Code also includes fish and shellfish. How do we apply your tracking standard to fish farms and shellfish farms in the state of Iowa?
Way. You show evidence that you show evidence that you supplied feed. You show evidence that they consumed the feed and that the proceeds that were generated at whatever time were directly related back to that feed supply and the value added. Remember, all of the ag liens, and especially and this was in Oyens 1, was emphasized, it's value added. The whole point, the whole idea of protecting the bank who's already added and getting in front of the bank is the fact that just like a PMSI, the idea is there's no harm, no foul.
That isn't the definition of the lien. So your position is, you know, I guess I'll be the fat guy and we'll let Justice McDonald be the law guy. But on the facts, if we review Johnson's affidavit and we disagree and we conclude that it's competent evidence, we're done with the FF. Is that fair?
Fair. First of all, his records are directly contrary to the dairy inventory reports, which both sides agree, I think, are inaccurate. But it certainly creates a fact issue with a person. I mean, that's like Mr. Story himself provided an affidavit. There's no foundation, there's no support for the statements that he makes. He makes the claim, generally, feed that's delivered to a farm is fed to the livestock. Well, I don't need an expert to tell me that, right? And so, no, I don't think it gets us there. We still have to connect the cattle that were remaining a year and a half, well, 13 months later, to the feed that was supplied back then. So, Your Honor, I think, and I think you don't, if it's not consumed, there's no lien.
So if a dealer delivers feed and only a quarter of it's consumed for some reason prior to the livestock being sold, the lien only attaches for 25% of the value of the feed delivered.
Presumably have the right to the feed, unpaid feed, to take it back. But here you get cattle, you know?
Practice to repossess feed?
Not a clue. Not a clue, Your Honor. But I would say this, that, you know, we're looking at three separate entities, and neither the district court nor amicus nor my opponent want to talk about the three separate entities and the transactions that were going on between those entities. And they're really three parties, and they're three different parties. They did attempt, probably not very well, but they did attempt to keep track of transactions that when cattle moved from one location to another, one entity to another, they attempted to track that through intercompany receivables. How good a job they did, of course, we don't know because we have a bare bones record here. What we do know is that 1,500 cattle are unaccounted for. We do know that 117 cattle came in. We do know that the EFI lien is limited to $83,000. That's the total amount of their lien claim. So EFF might, Your Honor, be a different category, but EFI and Elmwood are not. And so, you know, we take up $30,000 here, $25,000 of adequate assurance payments that they got that they don't credit their bill for, which they do need to do under the bankruptcy code. You got that, you got the $25,000, you got...
And related to this, so my understanding of the statute is designed to facilitate dealers providing feed to potentially to farmers or producers who may be at risk in terms of credit, right? They want to make sure that the animals are fed. And by giving the feed dealers super priority, you facilitate that transaction and make sure the animals are fed, right? So what sense would it make then to have the priority of the lien and the validity of the lien dependent on the record-keeping ability of the farmer, where the dealer doesn't have access to the farm? I mean, you keep saying like there's no evidence about what happened to the cows, when the feed was delivered, which animals consumed the feed. All of that information is in control of the producer in a situation where the producer may already be at risk. The point is to protect the feed dealer from the producer.
Yeah, I don't know that I agree with that last statement, Your Honor.
Conditions and discovery from the producer.
It's tracing. It's classic Article 9.
On the record keeping of the producer.
On the record keeping of the producer, it's contingent on establishing and tracing your lien from where you put it in to the operation to where it comes out as proceeds. How do I connect one to the other?
Did you feed the feed to these animals? And he says, I have no idea. Then the lien is no good?
Your Honor, again, I mean, you can use reasonable inferences, you can use facts that you do have, that, have someone testify, I delivered the feed here if necessary. We're not mainly challenging that. I'm simply pointing out, using the fact that they don't even have evidence of delivery to point out just how little record there is to support this lien claim. That's it. I mean, do I believe that he actually resold feed? No.
They have super priority on the whole lien.
On the front end, it's on the back end. It's on the proceeds side. We're not fighting about the feed or the cows that were fed back in 2017. We're fighting about proceeds that were generated in 2019. That's the issue. I'm not really fighting about the front end other than as a jumping off point to say they didn't even bother to prove that the feed showed up. I mean, they didn't prove anything.
Embellishing a little bit, respectfully, because they had an affidavit with all their feed invoices and all of that, and proved up the amount of feed they did sell to. Isn't that right? Okay, and then they have this affidavit that the EFF heard when it was dispersed had many cows that had consumed the feed, but they don't have it for EFI. Isn't that a fair step?
Plus Elmwood. Well, anyway, Your Honor, I do think, I suggested, probably without much hope, that what the court should probably properly do is affirm the Court of Appeals insofar as it reversed summary judgment and grant us summary judgment. But at the very least, this is clearly a fact-based dispute that the Court of Appeals recognized, at the very least, requires a much more robust factual record than we have before us today. Thank you very much.
Thank you, Justice. I'll do some jumping around, responding to a few different things that came up. Specifically, I think the question was raised, and what happened in the 13 months following, right? That's what the Court of Appeals kept asking. What about that delay in time? Well, there's evidence in the record, sure, that cows must have died or went missing, but that doesn't affect the cows that were still there. Right? It doesn't tell us that any cows were added. It doesn't show us that there was any replacement of the herd. And that's where I do want to talk about the Elmwood issue, because counsel likes to bring this up as a really important thing. Well, there's actually three farms, and you only sold feed on credit to 2 of the farms. Well, for one, the Elmwood cows aren't among those that were sold to generate the cattle sale proceeds, that $1 million plus in sale proceeds. For another, the milk check from the Elmwood cows is about $100,000, or 1/3 of the total. Again, I assert to you, materiality matters. Cut them out and more than enough. But to the fundamental question, how do we know that cows from Elmwood weren't trucked into Iowa? How do we know that? Because it's in the herd schedules. It says right there, cows would go from Iowa to Elmwood.
What about why don't you have the same affidavit for EFI that you have for EFF?
I don't know if I have a great answer to that other than Jared Johnson. He worked with, to my understanding, both farms. Perhaps when he put together, he just treated them the same.
Sort of a thing that occurred to me as I was reviewing this case and getting ready for today. It kind of reminds me a little bit of these mortgage foreclosure homeowner mortgage foreclosure cases we saw after the financial crisis in 2008, 2009, where the mortgage company is going in, trying to foreclose, and the homeowner is raising this and raising that and raising this and raising that. And the court grants summary judgment, and then, you have to decide, was there really an issue of fact? And maybe it would have been just easier to have a very short trial to resolve the same issues. So there wouldn't. Did that occur to your client? I mean, maybe just let's have a very quick trial on these issues.
We teed up the motion for summary judgment. We did it because we needed to know what exactly is required by this statute, right? It's still unclear to me. The Court of Appeals didn't provide us very much guidance as to what the heck, what we're supposed to do on remand, right? That's why we brought it up, so that we could get an answer to that. And in our motion, we said if there's a dispute about the actual dollars and cents number, then we'll have that out at a trial. The court's perfectly capable of doing that. Grant summary judgment on our super priority, we'll figure out the rest later. But we needed to know, and we still need to know, and every farmer and every feed dealer and every bank in Iowa needs to know too, because right now, they don't. Feed suppliers are supplying feed, they're fattening up these livestock. It's for the bank's benefit, it's for the farmer's benefit, it's all on credit, and then we get to the end and things go south, and it's not unusual that 13 months or years pass between the supply of that on credit and what happened here. And the fact is, this type of record keeping just isn't going on. And we could take the deposition of Mr. Etcher and find out that he says, I don't remember. That was in 2017, right? 2019 when the sale occurred. We could track down each and every purchaser of the cattle that were sold. And we could ask them, did you mark the ear tags?
Let's say I'm a bank and I lent to just to Elmwood, all right, in this hypothetical, and I had a first position on all of Elmwood's assets, and I put good money into there. I have a property interest, one that's protected by the Iowa and the United States Constitution. And then it turns out that the Elmwood cows went over to the EFI and the EFF farms and were sold, and they never consumed any of your client's lien. And then it turns out that those proceeds are the ones that are being used to pay your client's lien rather than you know, my lien. I'd have a problem with that, right? And that it really would almost be a constitutional question because you have property interests on both sides, right?
You'd have to present evidence that that actually happened, Justice. Again, if you look at the herd schedules, it's not the case where Elmwood cows were coming over. They say transferred from EFF, transferred from EFI. The way this would work is that cows would get fattened up, I think, at the EFF location and then sent around to the other ones. But there's no evidence except for, I will concede, and then I will promptly wrap up if it's okay with you, Chief Justice. I will concede that there are 17 cows identified in the herd schedules that came from Elmwood. And certainly the bank could have a problem with that, and you could take those out of the proceeds, the remainder, and there's still more than enough to cover our lien 4 times over. Your Honors, again, I urge you, I respectfully request that you vacate the Court of Appeals. Give us some guidance on how to resolve this. Thank you.
Of Quality Plus Feeds versus Compeer Financial is hereby submitted, and the court is adjourned for today.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.